So welcome friends. In today's class we will discuss the most important one-liners or selective one-liners that I have selected for you for the purpose of your law related exams. It may be your judicial service exam, it may be your law officer exam, whatever it may be. These are helpful for the purpose of cracking the preliminary examination. And these questions, I think I have collected nearly about 400 one-liner questions. This total questions will be uploaded in 4 or 5 videos. This will be a series of videos. So if anyone is interested in noting down, he can write it down or be ready with your pen and paper. So let's start. Now CrPC one-liners, these I have collected, these are the materials I have collected from the internet, that you just, if you don't want to write, you can just listen the video, okay? So and regarding the quality of the video, I'm extremely sorry, as I'm not a professional YouTuber. I do it for the only for the purpose of my interest and for the purpose of my own study. So if you can kindly consider that lacuna, so we can go on. Okay, now CrPC one-liners. Now question number 1. CrPC came into force on 1st April 1974. 2. CrPC is divided into 37 chapters and 484 sections. CrPC extends to the whole of India, and except the state of Jammu and Kashmir, this is omitted by the Jammu and Kashmir Amendment Act 2019. Now, point number 4, reason for non-applicability of some of the provision of CrPC to the state of Nagaland have been stated by the Supreme Court in state of Nagaland versus Ratan Singh. Okay, this is very important. The reason for non-applicability of some of the provisions of CrPC to the state of Nagaland have been stated by the Supreme Court in state of Nagaland versus Ratan Singh. The subject of CrPC falls within the concurrent list, therefore it can be amended by the Parliament or any state legislature. Number 6, the unique features of CrPC is separation of executive from the judiciary. Number 7, the Code of Criminal Procedure Amendment Bill 1994 was passed by law on 5th May, on 5th May 2005. The Code of Criminal Procedure Amendment Act 2005 came into force on 23rd June 2006. The Criminal Law Amendment Act 2013 came into effect on 3rd February 2013. The classification of offences have been given. Now, 11, bailable offences, section 2A means an offence which is shown bailable in the first schedule under CrPC, or which is 2, which we have to remember. Okay, now point number 12, non-bailable offence. First we go to bailable offence 2A, then non-bailable offence means any other offence. Here, grant of bail is a matter of discretion of the court. Okay, non-bailable offence means any other offence where grant of bail is a matter of discretion of the court. Now, cognizable offence 2C, a police officer may arrest an accused without warrant and can investigate without seeking permission from the magistrate. We all know that for the purpose of investigation, starting an investigation on cognizable offence, the police officials have to inform the magistrate and seek permission from him. But in case of cognizable offence, the very characteristics of the cognizable offence says that in a cognizable offence, what is a cognizable offence? Cognizable offence means a police officer in which a police officer may arrest an accused without a warrant and can investigate without seeking permission from the magistrate. Very, very important. Now, 14, in a non-cognizable offence 2L, the police officer has no authority to investigate without the order of the magistrate, and he can't arrest a person without a warrant. Just I have told about it. Now, 15, the nature of cognizable offence is bailable and simple. So always remember, non-cognizable offence is always bailable and simple. Punishment is simple. So nature of non-cognizable offence is bailable and punishment provided is simple punishment. Okay. Now 16, complaint as provided under section 2D is an allegation made in writing or oral. So complaint, it may be in writing or maybe in oral form. Okay. Now coming to 17, complaint can be made both for both cognizable and non-cognizable offences. So for the purpose of from the perspective of complaint can be made for both cognizable and non-cognizable offences. 18, complaint does not include a police report. You just have to remember these things. Okay, now when the question comes, if you remember these one liners in a rhetoric manner, now then the answer will automatically click on your mind that complaint does not include a police report. 19, complaint is made to a magistrate. So a complaint always made to a magistrate. Always remember that to the police authorities we give information, which in turn police records as first information received by the police officer. Okay, that is the provision of the FIR. Okay, now whenever it comes to the terminology of complaint, then a complaint is made to a magistrate only. Now the term inquiry has been defined under section 2G of CrPC. This is to, you have to remember that inquiry has been defined where under section 2G. 21, inquiry means every inquiry other than a trial conducted under CrPC by the magistrate or court. So whenever the inquiry conducting authority is always the magistrate or the court. Okay, inquiry means every inquiry other than trial. The inquiry does not include trial. Okay, other than trial conducted under CrPC, under the provisions or rules mentioned by this court, under CrPC by magistrate or court. 22, inquiry is conducted prior to framing of charges. This is very important to remember that inquiry is always conducted prior to framing of the charge. The stage is prior. Now 23, the term investigation has been defined under section 2H. So inquiry 2G and investigation 2H. Investigation is conducted with an object to collect evidence and a magistrate can't interfere in it. Very important point that whenever the investigating authority whenever the case is under the supervision of the investigating authority, the magistrate or the court do not have any power to interfere within it. Okay, so investigation is conducted with an object to collect evidence. So at the stage of collecting evidence, a magistrate can't interfere in it. 25, investigation can be conducted by a police officer and a person who is authorized by magistrate. So investigation can be conducted by a police officer in general cases and in special circumstances. So if a magistrate authorizes a person, then that person can also conduct the investigation. That's why it has been said that investigation can be conducted by a police officer and a person who is authorized by the magistrate. 26, the foundation of investigation is complaint and FIR. So if the complaint is to the magistrate and the magistrate directs the police authority to investigate the matter, then the investigation starts. And if the information is given to the police authorities, then the police lodges or receives the first information report, and according to the nature of the offence which have been transpired from the information given, whether it is a cognizable or non-cognizable, the police official starts the investigation. In case of cognizable offences, it has the authority to start the investigation on its own, and in case of non-cognizable offences, it has to seek the power of the concerned magistrate. So foundation of investigation is always what? Complaint and FIR. 27, the term offence has been defined under section 2N of CrPC. The term police report has been defined under section 2R. So 2G of CrPC inquiry, 2H investigation, 2N offence, 2R is police report. Report at 2R. This is the process, you remember this thing. Okay, 2R are for report. Now 29, the term public prosecutor as defined under section 2U. Public prosecutor 2U of CrPC means and includes any person appointed under section 24 and any person acting under the direction of the public prosecutor. So public prosecutor, sorry. Public prosecutor is a person who has been appointed under section 24 of the Code of the Civil Criminal Procedure, and also any person who is acting under the direction of the public prosecutor. Point 30, now warrant case section 2X. So warrant case is provided under section 2X, which means a case relating to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. So this is very important definition. 2X says about warrant case, and warrant case, this is imprisonment for 2 years or more. These are the cases from the perspective of the punishment, we decide it is a warrant case or a summons case. Now, summons case 2W says about the summons case means a case which is not a warrant case, that is a case relating to an offense punishable with imprisonment for a term not exceeding 2 years. So less summons case, above 2 years or above, this is a warrant case, and up to 2 years, this is a summons case. Now 32, victim is defined, very very important. Victim is defined under section 2WA of CrPC as a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged. Okay. Any loss or injury caused by reason of the for which the accused person has been charged. Okay. Now there is also very important part of this definition, that is victim includes victims, legal guardian and legal heir. Okay, so the term victim also includes the victim's guardian and legal heir. 34, judicial proceeding includes inquiry and trial. So the term judicial proceeding includes in itself inquiry and trial. Now 35, state government may by notification declare that any area to be a metropolitan area for the purpose of CrPC whose population exceeds 1 million. So it is the authority of the state government in case of declaring any area to be a metropolitan area, and the criteria is the population is above exceeds 1 million. Okay, now 36, children's courts under Juvenile Justice Act 2000 and Panchayat Adalats are not criminal courts. You just remember this thing, very very important point to remember, that children courts under the Juvenile Justice Act 2000 and Panchayat Adalats are not criminal courts. These are courts but not criminal courts in the sense we read CrPC. Okay. Now 37, court of session shall be established by the state government. This is section 9. Now section 10 says an assistant session judge is appointed by the high court of the concerned state. So an assistant session judge will be the appointing authority. The assistant session judge is appointed by the high court of the concerned state. Now then another important, high court may upon the request of central government, request of central or state government, confer upon any person who holds or has held any post under government all the powers of a judicial magistrate. Okay, such a magistrate shall be called special judicial magistrate. This is the provision of section 13 dealing in special judicial magistrate. Now the high court may upon request of the central of the state government. Okay, so who will confer the power of the judicial magistrate upon a person who is not belonging from the field? This is the authority is given to the Honorable High Court. Now 40, special judicial magistrate shall be appointed for a term not exceeding 1 year at a time as may be directed by the High Court. So the person appointed as a special judicial officer, he can be appointed for the term of 1 year at a time or not exceeding 1 year at a time. Okay, that same person, that very person can be appointed again on the completion of the 1 year, but at a time he cannot be appointed for a term exceeding 1 year. Okay, 41, local jurisdiction of a judicial magistrate is under the control of chief judicial magistrate subject to the general controls of the courts. Okay, section 14 says subject to high court's general control. So high court is the custodian of the entire judicial process of a state. Okay, so the local jurisdiction of a judicial magistrate is under the control of the chief judicial magistrate subject to high court control. 42, chief judicial magistrate may make rules or give special orders from time to time consistent with CrPC as to distribution of business among the subordinate judicial magistrates. This is the provision mentioned in section 15. So who is the chief judicial magistrate? A magistrate of the first class from the group of the persons, any one of the magistrate of the first class in regard to whom the Honorable High Court the power of the chief judicial magistrate, that person is magistrate. Always remember that the chief judicial magistrate and the other judicial magistrate are in every respect except designation are equal. They are equal. Chief Judicial Magistrate is the team leader of the judicial magistrates. Okay, there is no superior quality or inferior quality. That he is the Chief Judicial Magistrate just because the High Court says so. He is the team leader. He will the entire team. Okay. This is the process. Now, coming to 43, the number of courts of judicial magistrate in a district is decided by the state government. So, this is the domain of the state government, that how many courts of judicial magistrate has to be established in a state or in a district. Okay. Now, 44, a person is eligible to be appointed as a public prosecutor only if he has been in practice as an advocate for not less than 7 years. So, section 24 mentions, remember this term, that in case of public prosecutor, the eligibility criteria of a practicing advocate is not less than 7 years. Okay. 45, a person can be appointed by central or state government as a special public prosecutor only if he has been in practice as an advocate for not less than 10 years. Section 24. A person can be appointed by central or state government as a special public prosecutor. A person can be appointed by central or state government as a special public prosecutor only if he has been in practice as an advocate for not less than 10 years. This is also mentioned in 24. So, public prosecutor 7 years and special public prosecutor 10 years. 46, state government is authorized to appoint a public prosecutor for a district. 47, assistant public prosecutor can be appointed under section 25. So, 24 is the public prosecutor and special public prosecutor dealing with special public prosecutor, and 25 is assistant public prosecutor. Now, 48, district magistrate can appoint a police officer as an assistant public prosecutor for the courts of a magistrate. These are the power given to the highest rank of the executive magistrate, that is the district magistrate, can also appoint a police officer in as an assistant public prosecutor for the courts of a magistrate. 49, public prosecutor and assistant public prosecutor represents the government. This is very simple. 50, Directorate of Prosecution as appointed under section 25A. Always remember, very, very important. And this came through an amendment. This is a new provision. Comparatively new provision, not so new. So, this has been asked in many exams. So, what is the provision of the Directorate of Prosecution? That is section 25A of CrPC, shall function under the administrative control of the head of the Home Department of the state. So, the establishment of the Directorate of the Prosecution and the functioning of and administrative control of the Directorate of Prosecution shall be under the control of the head of the Home Department of the state, not under the High Court. Always remember that this is the domain of the state government. Okay. Now, section 25A was inserted in CrPC by CrPC Amendment Act 2005. This is also important to remember. At 25A, dealing in Directorate of Prosecution, has been amended, introduced by the Amendment Act of 2005. Okay. Now, 52, any offence under IPC may be tried by High Court or the Court of Session or any other court by which such offence is shown in the schedule to be triable. Where it has been said? It has been said under section 26A. Okay. So, which court will try the offence has been shown in the schedule of this court. Okay. Now, 53, any offence under any other law shall, when the court is mentioned in such law, that such law means this is talking about the special law. Always remember that if there is a special provision regarding any special subject matter or regarding any subject matter, there is a special law, then the rule is special law always override the general provision. Okay. So, any offence under any other law, 53, concentrate on 53. Any offence under any other law shall, when a court is mentioned in such law, be tried by such court, and when no court is so mentioned, may be tried by the High Court or any other court by which such offence is triable under the first schedule 26B. So, if that special law or enactment says about any specific court, that court will be entitled to entertain or have the trial of that offence. If nothing is mentioned, then the High Court, and if then the High Court, or if the High Court thinks that the offence can be sufficiently be tried by any other court inferior to it, then any other court by which such offence is triable under first schedule. So we will have to look at the punishment provision of the offence, and then we will decide. That means below 7 years it is to the magistrate, above 7 years it is to the court of the session. Okay, so this is 26b. Now coming to section 27, 54, point number 54, please concentrate. Any offence not punishable with death or imprisonment for life committed by any person under the age of 16 years when brought before the court. This is very important. When brought before the court, person under the age of 16 years when brought before the court. That means it doesn't matter when he committed the offense. Person brought before the court is under the age of 16 years, may be tried by a chief judicial magistrate or by any court specially empowered under the Children's Act 1960. This is section 27. Now 28, High Court may pass any sentence authorized by law. This is the supreme power of the High Court in case of criminal matters, that High Court may pass any sentence authorized by law. There is power, but there is factors on it. Powers comes with responsibility. We will read about the section 484, 482, and this is another provision, section 28. Always remember that inherent powers of High Court in case of criminal matters, it is 482, and general power of the High Court may pass any sentence authorized by law is provided in section 28. Now 56, a session judge and additional session judge may pass any sentence authorized by law. They have also unfettered powers, but death sentence passed by any such judge shall be subject to confirmation by the High Court. Under section 28, it has been provided that session judge and additional session judge. This is not talking about assistant session judge, because assistant session judge is having the limit of up to 10 years. Okay, so session judge and additional session judge may pass any sentence authorized by law, but death sentence passed by any such judge shall be subject to confirmation by the High Court. This has been provided, I think it is 366 of the Code of Civil Procedure. We will discuss in detail. Now 57, an assistant session judge may pass a sentence up to. This has been also provided under section 228. So High Court have unfettered power, any sentence authorized by law. Session judge and additional session judge may pass any sentence authorized by law except death sentence, in which case the confirmation of the High Court is required before execution. That means subject to the confirmation by the High Court. And assistant session judge may pass any sentence up to 10 years. These things have been provided in section 28. Okay, now 58, a chief judicial magistrate pass any sentence up to 7 years or any fine up to fine. Okay, CGM, it is CGM. The monetary power has not been limited in case of chief judicial magistrate. So chief judicial magistrate may pass any sentence up to 7 years and or any fine. Okay, 29, and a judicial magistrate of first class may pass any sentence up to 3 years or a fine up to 10,000 rupees, and a judicial magistrate of the second class may pass any sentence up to 1 year and a fine up to 5,000. These three things are provided in 29. 28, High Court, session judge and additional session judge, exception death sentence, assistant session judge 10 years. 29, chief judicial magistrate 7 years unlimited fine, first class 3 years 10,000, and second class 1 year 5,000. This is the way you remember. Now 66, sentence of imprisonment in default of fine is provided under section 30 clause 1, according to which a magistrate shall not exceed 1/4 of the term of imprisonment which the magistrate is competent to inflict as punishment for the offence otherwise than as imprisonment in default of payment of fine. So sentence of imprisonment in default of payment of fine is provided under section 31, and according to which a magistrate shall not exceed. What is the limit? That is 1/4 of the term of imprisonment which the magistrate is competent to inflict as punishment for the offence. So if the offence is punishable for with 4 years of imprisonment, then in case of default of fine in such a case, with the the original punishment purpose of default of payment of fine, the court cannot sentence him for more than 1 year. Okay, 4 years, then 1/4 is 1 year, more than 1 year. Okay, now 62, the imprisonment awarded in default of fine may be in addition to a substantive sentence. That is what I'm, that is the terminology what I'm looking for, that is substantive sentence. Okay, the principal sentence is substantive sentence awarded by the magistrate for the offense that has been mentioned in 30 clause 2. So the substantive sentence and the imprisonment for in default of fine can be, the imprisonment awarded in default of fine may be in addition. It is not the rule that it is always in addition. It is always have to be in addition to the substantive sentence, but it may be. So it may run concurrently or it may run consecutively. Okay. Now 63. When a person is convicted at a trial of 2 or more offences, the court may, subject to section 71 IPC, sentence him for such offences, and such punishments may run either concurrently and or consecutively. 31 clause 1 says, when a person is convicted at a trial of 2 or more offences, the court may, subject to section 71 IPC, sentence him for such offence, and such punishments may run either concurrently and consecutively. The rule is, if nothing is mentioned, the running of the punishment will be concurrently. Okay. Now 64, in case of consecutive sentence, the person shall not be sentenced to imprisonment for a period longer than 14 years, and also the aggregate punishment shall not exceed twice the amount of punishment which the court is competent to inflict for a single offence. So in case of consecutive sentence, the person shall not be sentenced to imprisonment for a term or for a period longer than 14 years. So if that person have committed 5 offences, each of them having the punishment of 3 years, then 5 into 3, that is 15 years. Now in such a case, if that runs consecutively, that means one after another. So the provision of 31 clause 2 says, now in such a case, in a case of consecutive sentence, the provision shall not be, the person shall not be sentenced to imprisonment for a period longer than 14 years. Okay. And also that the aggregate punishment shall not exceed twice the amount of punishment which the court is competent to inflict for a single offence. So for a single offence, the court is competent to inflict, in case of our examples, is 3 years. Now first of all, it not in any case exceed the 14 years limit, and second, twice the amount of the of a single offence, that is 3 years plus 3 years, that is 6 years. So in that, in our, for the purpose of our example, that person can be extremely or for that matter, most to most can be punished for 6 years only. Okay, that has been provided in 31 clause 2. Now police officer 65, it's point number 65, police officer superior in rank to investigation officer IO may exercise the same powers throughout the local area to which they are appointed as may be exercised by such officer. That has been provided under 36. These are provisions dealing with the powers of the police authorities. Now if the is investigating officer, police officer superior in rank of investigating officer, always have the power to powers the local area to which they are appointed as may be exercised by such investigating officer. 36. Now 37, point number 66 says, public to assist a magistrate or police officer reasonably demanding is 8. That is 37. This is very important. Several times have been asked in several exams, that what is the provision under which the public is bound to assist a magistrate or police officer reasonably demanding is 8. Okay, there are 3 grounds, that is apprehending person, apprehending arrest, or absconding, or destroying the railway property, or the government's property. These are the will read in detail. Now section, according to 37, public is bound to assist a magistrate or a police officer reasonably demanding is 8. Now 67, section 39 provides public to give information of certain offences to be given to public officer. Now 37 and 39 is different, always remember. 39 provides public to give information of certain offences. They are not bound, but information of certain offences to be given to police officers. Okay. In case of 37, the police authority is demanding his aid, demanding that public, that individual's aid or help. But in case of 39, this is general public giving information of certain offences to the police officers. 68. Under section 41, a police officer can arrest a person without an order of the magistrate and without warrant. This is very important. The 41 is a very big section. We will have to read in detail. Just for the purpose of this while one-liners, remember that section 41, a police officer can arrest a person without an order of the magistrate or without a warrant under section 41. Now, under section 41A, a police officer shall issue notice directing a person against whom reasonable complaint has been made or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offence, or to appear before him or at such place as specified in the notice. So section 41A deals with the notice by the police officer to a person against whom a reasonable complaint has been made or a credible information has been received or a reasonable suspicion exists. There are three grounds: complaint, reasonable credible information, and reasonable suspicion exists that he has committed a cognizable offense. Always remember that this is a cognizable offense. Okay. Now, if the person to whom the notice is issued under section 41 fails to comply with the terms of the notice, the police officer may arrest him for the offense mentioned in the notice. Okay, so 41 compliance of the non-compliance of the 41A notice is a good ground of the police officer to arrest him. Okay, every police officer while making the arrest shall inform the person arrested that he has a right to have a relative or a friend named by him to be informed of his arrest. That is 41B. These are the provisions which have been introduced after the landmark judgment of the D.K. Basu versus State of West Bengal. Always remember that case law, the D.K. Basu versus State of West Bengal, under which the Honorable Supreme Court have given the guidelines for the purpose of making of the proper and valid arrest by the police authorities. Okay, so every police officer making the arrest shall inform the person arrested that he has a right to have a relative or friend named by him to be informed for his arrest. 41B. Now 41C, the state government shall establish a police control room in every district and state level. So 41A notice, 41B says that give information to the person, the relative or friend named by him to be informed. And 41C says police control room. Now 41D says when a person is arrested and interrogated by a police officer, he shall be entitled to meet an advocate of his choice during interrogation, though not throughout the interrogation. So if a person is arrested and interrogated by the police authorities under the lockup or the police station, now in such a case he has a right to meet an advocate of his choice during interrogation. That for the purpose of if that person have been given custody of 7 days by the court to the police authorities, now in such a case within the 7 days many a times his advocate can meet his client, but not throughout the investigation. Means when the police is interrogating the accused person, at that very moment the lawyer cannot be present. Okay, now coming to 74, which says any person in the presence of police officer has committed or has been accused of committing a non-cognizable offense, refused to give his name or residence, he may be arrested by the police officer. This has been said in 42. Okay, so not giving or refusing to give his name or address, he may be arrested by the police officer. So refusal to give name and address, it gives the police authority to arrest a person on which the police authorities has reasonable suspicion that he has committed or has been accused of committing a non-cognizable offense in the presence of the police officer. Okay, now 75, point number 75, a private person may arrest a person who is in his presence commits cognizable or non-cognizable offense. So arrest by the private person, the provision is section 43, and when a private person can arrest, a private person may arrest any person who in his presence commits a cognizable and non-bailable offense. cognizable. And so these are the provision 42 and 43, where first of all the police authorities, you see that in the presence of a police officer where the commission of the offense or has been accused of committing a non-cognizable offense, in the presence of a police officer there is no requirement of any reasonable suspicion or having credible information. These requirements are already have been done with. Okay, in such a case the police officer is present himself. And another provision is section 43, where the private person in the presence, a private person may arrest any person who in his presence commits a non-cognizable, cognizable and non-bailable offense. So this is 43. 46, a magistrate, executive or judicial may himself arrest or order any person to arrest a person who commits an offense in his presence. So first of all, 42 police officer, 43 private person, and 44 is magistrate, whether executive or judicial. If in his presence any person commits an offense, then that magistrate always have the authority to arrest that person. Now 45, no magistrate of the armed forces of the union shall be arrested for anything done in the discharge of his official duties except after attaining the consent of the central government. Okay, so no member of the armed forces. I'm sorry, I may have misspelled the member with the word magistrate, but you people are very intelligent. You know, I think you have got my mistake. So point number 77 says, no member of the armed forces of the union shall be arrested for anything done. Remember this word, anything done in the discharge of his official duties. Okay, anything done if in the execution of his official duties he fires shots at a violent mob and some people died, then also he cannot be arrested because he is executing his official duties. So in discharge of his official duties except after attaining the consent of the central government. This has been provided in 45. Okay, now coming to 78. In case of Joginder Singh versus State of UP, all very, very important, please note that in case of Joginder Singh versus State of UP, it was held that even a man of necessary due to circumstances, it was held that even a man, if necessary due to circumstances, may arrest a woman during a daylight. This is a very landmark judgment, a very important. This is a rule-breaking judgment, so in which it was held that even a man, if necessary, due to circumstances, may arrest a woman during daylight. Okay, so always remember the arresting of a woman must be within the daylight, and in this case, the Honorable Court said that even a man can arrest a woman if the circumstances are such. Okay. This is the case of Joginder Singh versus State of UP. Now, coming to 79, point number 79, please concentrate that no woman shall be arrested after sunset and before sunrise, as added in section 46 in exceptional circumstances with the prior permission of the judicial magistrate of the first class. So the rule is that no woman shall be arrested after sunset and before sunrise. That means the night time or the dark time. No woman shall be arrested, but however, she can be arrested in exceptional circumstances with the prior permission of the judicial magistrate of the first class. 80, point number 80, please concentrate. Section 50 provides that every person arrested without warrant shall be informed of grounds of arrest, and if right to bail, if the arrest is made, for bailable offense. Okay, so the person, first of all, the person must be made aware of the grounds of arrest for the offense for which he have been arrested, and if there is a right to bail, if there is a right to bail or the offense is bailable, then that person must be made aware that he has to give bail for his offense. However, if there is non-compliance of this, then it shall render the arrest and detention of the person concerned illegal and shall enable the person arrested move for habeas corpus to obtain his relief. If now very, very important, if these provisions have not been complied with, then the person will be entitled to move a writ petition of habeas corpus before the Honorable High Court. Okay, for illegal detention. Okay. Point number 80. Now, point number 81, section 53. What section 53 says? Section 53 says that Section 53 CrPC provides that for the examination of accused by medical practitioner at the request of the police officer, here where there are reasonable grounds for believing that an examination of his person will afford evidence as the commission of the offense, as to the commission of the offense, then the concerned medical authority at the request of the police officer examine that person. That have been provided under section 53. Well, just remember that section 53 deals with examination of accused by medical practitioner at the request of police officer. Examination of accused, section 53. 53A talks about examination of person accused of rape by medical practitioner of the police officer. Now 53, general accused person, examination of accused person in any other case by the medical practitioner at the request of the police officer. 53A specifically deals examination of person accused of rape by medical practitioner at the request of the police officer. I'm sorry. Now 83, when any person is arrested, he shall be examined by a medical officer in the service of the central or the state governments. This have been said in section 54. So the medical authority or medical practitioner who will be a competent medical practitioner for the purpose of the CrPC, now he shall be examined by a medical practitioner in the service of the central or the state government. Okay, now there are exceptions to this provision too. Okay, because always these persons, the registered medical practitioner who is in the service of the central and state government, always they are not available, and there are some offenses just like in case of rape. Now the time factor within the which the examination have been done is a very important factor. Okay, defeats justice in such cases. In such cases, one can resort to the private practitioners too, though there are certain credentials mentioned for that purpose. Okay, now coming to when any person is arrested, point number 83, when any person is arrested, he shall be examined by a medical officer in the service of central or the state. Section 54. Under section 54A, the magistrate may direct the person so arrested to subject himself to identification by any person. Under Indian Evidence Act, the state test and the identification have been mentioned under section what? Under section 9 of the Indian Evidence Act, where it have been provided the identification of any person or thing or person. So that is section 9 of the Indian Evidence Act. Now under section 54A, the magistrate may direct the person to arrested to the identification of any person. Okay, now 85. Point number 85, it is mandatory to produce the person arrested before the magistrate within 24 hours of arrest have been provided in section 57. Very important. Remember that it is a person arrested must be produced before a magistrate within 24 hours. What is the provision? The provision is section 57 of the Code of Civil Procedure. Now, section 60 what says? If a person is in lawful custody escapes, if a person in lawful custody escapes, the person from whose custody he escaped may immediately pursue and arrest him in any place in India. That has been provided in section 60. So if any person escapes from any lawful custody, now in such a case the custodian have the power to pursue that person throughout the territory of India. There will be no bar as to the jurisdiction. If a convict person escapes from the clutches of the police authorities, then the police authority have the power to chase him throughout the territory of India. There will not be any bar of their jurisdiction of the police station. Okay. Now, the very important provision. Okay. Now, coming to section 61. Every summon issued by a court shall be in writing, duplicate, signed by the presiding officer or any other officer authorized, and shall bear the seal of the court. Very, very simple. Now, 62. Summons may be served by police officer or an officer of the court or by an authorized public servant. Okay. 62. 63 says, now from section 61, the provisions of summons under the Criminal Procedure Code have been started. We are dealing with that. Now 89, service of summons on corporate bodies and societies may be affected by serving it on the secretary, local manager or other principal officer of the corporation, or by letter sent by registered post addressed to the chief officer of the corporation in India. That has been provided in section 63. So First of all, 61 says summons must be in writing, duplicate signed by the presiding officer or any other person authorized, and what shall bear the seal of the court. 62 says summons may be served by the police officer or officer of the court or any other authorized public servant. And 63 says service of summons on corporate bodies and societies may be affected by serving it on the secretary, local manager or other principal officer of the corporation, or by letter sent by registered post addressed to the where chief officer of the corporation of India, corporation in India, where their chief officer sits, or where the office of the chief officer. Now 64, section 64 says where the person summoned can by exercise of due diligence be found, the summons may be served by giving it to some adult male member of the family residing with him in duplicate. It is under section 64 of the Civil Procedure Code. Okay. Now summons have been dealt with for the purpose of Civil Procedure Code, where that is order 5. Okay, and in case of Criminal Procedure Code, it is starting from section 61, and for the purpose of serving it to a male adult male member of the family residing with him in duplicate. Okay, 64. What is the purpose of giving it in duplicate? Because for the purpose of acknowledgement received, that person will sign one copy of the summon and hand it over to the delivery officer. Okay, now a servant is not a member of the family within the meaning of section 64. This is the explanation or clarification. Now, where summons can be served as provided in 62, 63 and 64, a serving officer shall affix the summons in duplicate to some conspicuous part of the house that have been provided in section 5 of the Code of Civil Procedure. Section 66, what it says? It says where a person to whom a summon is to be served in active service of the government, then summon shall be sent to head of the office. So section 66 says if the person to whom the summon is to be served is an active service or is an is in active service of the government, the summon shall be sent to the head of the office. 94, every warrant of arrest issued, point number 94, section 70. Okay, section 70, every warrant of arrest issued by a court shall be in writing, shall be signed by the presiding officer of the court, and it shall be bear the seal of the court. So after the provision of summons, we come to the provision of warrants from 70. 61 to 69 summons, and from 70 starting warrant. Always remember that once a warrant is issued, and unless it have been cancelled by the court or it till it is executed, these are the two circumstances under which the warrant gets satisfied or cancelled. Otherwise, the warrant remains in force for eternity, unless it is either cancelled or executed. So once a warrant is issued by the honorable court, unless it is executed or have been cancelled by the court, it remains in force for eternity. This is a very important thing to remember. Okay, now coming to this section 70, every warrant of arrest issued by a court shall be in writing, shall be signed by the presiding officer of the court, and shall bear the seal of the court. Section 70. Now after section 70, section 75, the police officer or other person executing a warrant of arrest shall notify the substance thereof to the person to be arrested, and if required shall show him the warrant. This is the provision, exact provision, that telling the person to be arrested by the police officers the content of the warrant or substance of the warrant, and if necessary, it must be it must be shown to him. Under section 77, a warrant of arrest may be executed at any place in India. So a warrant may be executed, a warrant of arrest may be executed at any place in India, irrespective of the fact that which court issued the warrant. Okay. Now section 82, a person who is avoiding execution of a warrant may be proclaimed absconded under section 82. So if the execution of the warrant is not cannot be possible, and the court is satisfied that the person avoiding the execution of the warrant, then the court can declare that person as an absconder. So or proclaimed offender or proclaimed absconder. So this is very important provision starting from section 82. A person who is avoiding execution of a warrant may be proclaimed absconder under section 82. Now coming to 82 clause 1. A proclamation under section 82(1) requiring a person to appear must be published, giving not less than 30 days time to the person concerned to appear at a specified place at a specified time. So the notice of proclamation containing the time, addressing the specified person, where to appear and on what time, on what date, must give the person 30 days time to the accused person. Now, in order to compel the appearance of a person who is absconding in spite of a warrant of arrest being issued against him, his property may be ordered to be attached. So, if that person still do not come, now in order to compel appearance of a person who is absconding in spite of a warrant of arrest being issued against him, his property may be ordered to be attached. Simultaneously with issuance of a proclamation under section 82, provided that the court is satisfied that a person is about to dispose of the whole or any part of the property, or is about to remove the whole or any part of the property from the local jurisdiction of the court, section 83. Now coming to our this video's last point number 100, that attachment of land paying revenue to the state government of a person absconding shall be made through a collector of the district where the land is situated. That has been mentioned in section 83 clause 4. So attachment of a land paying revenue to the state government of a person absconding shall be made through the collector of the district where the land is situated. Okay, 83 clause 4. So for this video, I think this much is enough. 100 important one liners. Please support me. Okay.